Representantes, inaasahang papabor daw dito sa usapin ng mga kaso ni former President Rodrigo Roa Duterte dyan sa Appeals Chamber ng International Criminal Court sa mga naunang desisyon ng pre-trial chamber na kinikilala ang jurisdiksyon ng korte sa mga kasong may kinalaman sa war on drugs campaign dito sa Pilipinas. Ayon yan kay International Criminal Court accredited lawyer Attorney Cristina Conti. Sa isang pahayag nga, sinabi ni Conti na malinaw na may jurisdiksyon ng International Criminal Court sa naturang kaso at kung sakali man na baligtarin ito ay magiging self-defeating ang buong proseso sa paglilitis na magtatagal ng mas mahaba pang panahon sa kanilang mga isinasagawang aktibidad. Ayon pa sa kanya, ang kasalukuyang yugto ay isa ng appeal stage kung saan ay may umiiral na desisyon mula naman sa pre-trial chamber na inilabas noon pang Oktubre. Bagamat wala pang ginagawang public hearing ay pinalabas at ipinaliwanag na ng International Criminal Court ang kanilang pasya na nagsasabing may jurisdiksyon ang korte sa naturang kaso. Sa puntong ito mga kabombo at mga ka-Star Nation, ang katanungan ngayon ay para sa appeal sa chamber ay kung tama ba na naging pasya nila para sa pre-trial chamber na may jurisdiksyon batay dun sa mga umiiral na batayan ng kanilang panig. Ang sasabihin niya ng appeals chamber ay walang sapat na dahilan para naman baligtarin ang naturang desisyon. Ang Appeals Chamber mga kabombo at mga ka-Star Nation ng International Criminal Court ang inaasahan na maglalabas ng pinal na pasya para sa usapin ng jurisdiksyon na isang mahalagang issue na nagpapatuloy pa rin na investigasyon kaugnay ng aligasyon ng crime against humanity na may kaugnayan sa kampanya kontra sa illegal na droga ng nakaraang administrasyon. Sa ngayon ay hinihintay pa ang magiging desisyon ng hukuman na maaaring magtakda ng direksyon para sa kaso sa mga susunod na hakbang ng international panel kaugnay doon sa mga paglilitis, mga kabombo at mga ka-Star Nation. At tabay din tayo mga kabombo at makakausap natin maya-maya si Attorney Efraim Cortez, ang presidente ng National Union of People's Lawyer, para ho dito sa mga update at kung ano yung kanilang mga expectation mga kabombo at mga ka-Star Nation. At sa pagkakataong ito, oras natin sa buong kapuluan ay meron na lamang ho tayong nalalabing 3 minuto bago sumapit ang alas 5 ng hapon at sa linya ng ating komunikasyon ay nariyan na si Attorney Efraim Cortez. Magandang hapon po sa inyo. Si Bombo Dennis Hamito po ito at live po tayo ngayon sa Bombo Radio Philippines. Napapakinggan at napapanood po tayo through digital channels ng Bombo Radio Philippines. Welcome to the program, Attorney.
Ang fearless forecast ko ay i-affirm ng appeal chamber ang decision ng pre-trial chamber na merong jurisdiction ng ICC over dun sa case against President Duterte. Ito yung aking fearless forecast. At may mga basis ako dyan. Unang-una, ang mga acts involved dito sa case ni Duterte were committed at the time that the Philippines was still a member of the ICC. Secondly, yung investigation was commenced in February of 2008. Yung preliminary examination was commenced in February 2018 by the Office of the Prosecutor. At ito yung nag-signal, nagsimula na yung proceedings. At dito titignan kung kailan nagsimula ang paglilitis kay Duterte ng criminal court. So hindi ito nagsimula noong June noong 2021 nung panahon na nag-authorize ang pre-trial chamber na mag-continue na ng preliminary investigation ng prosecutor. Kasi sa tingin natin, yung preliminary examination ay part ng isang single proceeding at nai-initiate ito through an examination na ang purpose ay to determine whether may na-commit na crimes against humanity. Ibig sabihin, nandun lahat yung gravity, whether widespread, whether systematic, i-determine nila yon. And ang purpose is to determine whether to initiate a formal investigation. So, nung inauthorize ng pre-trial chamber ang Office of the Prosecutor to conduct the preliminary investigation, ay nagkaroon lang ng progression ng proceedings from examination to a formal investigation through the preliminary investigation. Na ang purpose na dito ay to zero in on who are to be held accountable for the acts ng crimes against humanity that was determined na may nangyari nga sa Pilipinas. So when you try to determine when did the jurisdiction of the ICC attach, nag-assume sila ng jurisdiction in February 2018 when the Office of the Prosecutor started the preliminary examination. At hindi noong 2021 start ang preliminary investigation. We have to consider the fact that isang court lang yung ICC composed of the prosecutor and the different chambers. And at the same time, there is one single proceedings in the investigation commencing from the examination until makapunta sa trial. Ang position ko. And considering na the acts were committed at the time.
Yun. With that, maraming salamat po, Attorney Cortez. Babalikan ko po yung linya nyo maya-maya lamang sapagkat I think nagsimula na ho yung development dyan sa International Criminal Court. Mga kabombo at mga ka-Star Nation, ating pakinggan at panoorin ang mga kaganapan sa International Criminal Court sa Dahay.
Luz del Carmen Ibáñez Carranza, presiding in this appeal against arising from the case of Mr. Rodrigo Roa Duterte. My fellow judges in this appeal are Judge Tomoko Akane, Judge Solomi Balungi Bota, Judge Gocha Lord Kipanitze, and Judge Erdene Balsuren Damdin. I will allow now the parties and participants to identify themselves. First, the defense, please. You have the floor.
Good morning, Your Honours. As you're aware, the former President, Rodrigo Duterte, has been excused appearance today. The defence is represented by myself, Attorney Nicholas Kaufman, Dr. Dov Jacobs, Attorney Davide Rancati, Maître Alexandre Dezev-Davi, Attorney Kaylin Chell, and Nicholas Russo.
Thank you. Now, please, the Office of the Prosecutor, please. You have the floor.
Good morning, Your Honours. The Office of the Prosecution is represented by Matthew Cross, Appeals Counsel, Edward Jeremy, Trial Lawyer, and myself, Mary Che Regue, Appeals Counsel.
Thank you. Finally, the Office of the Public Counsel for Victims, please.
Good morning, Madam President, Your Honours. The Common Legal Representative Team for a Participating Victim is composed today by Mr. Joel Butuan, Counsel, Mr. Orcholon Naransetsek, Legal Officer, Ms. Anne Grabowski, Legal Officer, and myself, Paulina Masida.
Thank you. I take it that the attendees are the same as the ones appearing on the list which the court officer kindly provided to the appeals chamber before the hearing. If the composition of any of the teams has changed, please notify the court officer by email. I note for the record that Mr. Duterte is not present in the courtroom as he has waived his right to be present and the appeals chamber has authorized it. His written waiver has been filed on the record. He is represented by his counsel. Today, the appeals chamber will deliver its judgment in the appeal of Mr. Duterte against the pretrial's first decision of the 23rd October 2025, entitled Decision on the Defense Challenge to the Jurisdiction of the Court, which I will refer hereinafter as to the impugned decision. In that decision, which bears the document number 309 in the case record, the pretrial chamber found that the court can exercise its jurisdiction in the present case over the crimes alleged against Mr. Duterte that were committed on the territory of the Republic of Philippines while it was a state party. This is a non-authoritative summary of the appeals chamber's written judgment in the appeal. The authoritative version is the written judgment, which will be made available and notified after this hearing. Background of the appeal. I will start with a brief background to this appeal. As I have already mentioned, the pretrial chamber issued the impugned decision on the 23rd October 2025. On 14 November 2025, the defense submitted its appeal brief, raising 4 grounds of appeal and requesting the appeals chamber to reverse the impugned decision, to find that there exists no legal basis for the continuation of the International Criminal Court's proceedings against Mr. Duterte, and order his immediate and unconditional release. On 8 December 2025, the prosecutor and the OPCV responded to the appeal brief requesting the appeals chamber to confirm the impugned decision. Upon invitation from the appeals chamber, the prosecutor and the OPCV filed on 16th January 2026 additional observations on various issues considered necessary for the proper disposal of the appeal, and the defense filed a response thereto on the 23rd January 2026. The appeals chamber's judgment. I shall proceed to outline the decision of the appeals chamber on the merits of the appeal. First ground of appeal. Under its first ground of appeal, the defense contends that the pretrial chamber erred in finding that Article 127.2 is lex specialis with respect to Article 12. The appeals chamber recalls that the impugned decision, the pretrial chamber considered the effects of the withdrawal of the Philippines from the statute in circumstances in which the pretrial chamber granted the authorization to proceed with an investigation pursuant to Article 15.3 after the withdrawal had become effective. It concluded that Articles 12.2 and 13C, which I will refer to hereafter as provisions in Part 2, read in isolation, would not support the court's jurisdiction in the present case. However, in the interpretation of the pretrial chamber, Article 127.2 operates as lex specialis applicable to circumstances of a state party's withdrawal from the statute, with the effect that the court retains jurisdiction in the present case. The appeals chamber considers it important to determine the scope and meaning of these provisions, pursuant to Articles 31 to 33 of the Vienna Convention on the Law of Treaties, which require, inter alia, that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. The appeals chamber notes the wording of the heading of Article 12 addressing the preconditions of the exercise of jurisdiction. Within those preconditions, Article 12.2 stipulates that the court may exercise its jurisdiction if one or more of the following states, i.e., the state on the territory of which the conduct in question occurred, or the state of which the person accused of the crimes is nationals are parties to this statute. The appeal chamber particularly underlines that this article uses the present tense, which implies that a contemporaneous assessment is required. The appeals chamber rejects the argument of the prosecutor that the use of the present tense may plausibly reflect drafting convenience or even oversight, rather than the introduction of a restriction on the court's exercise of jurisdiction. The appeals chamber observes that during the discussion leading up to the Rome Conference, the adoption of Article 12 proved to be perhaps the most difficult compromise in the entire negotiations. Therefore, it cannot be assumed that this language, which is repeatedly and interconnectedly employed in Part 2 of the statute, can be easily dismissed as accidental. Rather, this wording lends support to the interpretation that the relevant states must be parties to the statute at the time the court exercises its jurisdiction. Articles 11 to 15, all referring to the exercise of the court's jurisdiction, are interconnected and must be subject to a systemic reading. Pursuant Article 12.1, there is a point in time at which a state becomes a party to the statute and accordingly accepts the jurisdiction of the court with respect to the crimes listed in Article 5. From this point in time, jurisdiction exists with respect to the relevant state until the acceptance is revoked by a state party's withdrawal from the statute. However, according to the statutory framework, the existence of jurisdiction needs to be distinguished from the exercise of jurisdiction. In situations of a state party's withdrawal from the statute, these provisions must also be assessed in light of Article 127, which addresses specific circumstances and determines that the withdrawal shall not prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective. The appeals chamber observes that the provisions referred to above must also be interpreted in line with the object and purpose of the statute, which is to put an end to impunity for the perpetrators of the most serious crimes of concern to the international community as a whole, and thus to contribute to the prevention of such crimes. It would be incompatible with this object and purpose to enable a state party to evade its responsibilities under the statute by depositing a written notice of withdrawal once it discovers that alleged crimes committed on its territory or by its nationals are being examined by the prosecution. At the same time, the state's right to withdraw from the statute would not be effective if the court were able to exercise jurisdiction indefinitely, despite the state no longer being a party. The present interpretation ensures an appropriate balance between the ability of states to effectively withdraw from the statute and the responsibilities that states accept upon ratification of the statute, whilst providing a clear timeline within which the examinations must be pursued. The appeals chamber now turns to the contention of the defense under the first ground of appeal, namely that the pretrial chamber erred in law by construing Article 127.2 as lex specialis vis-à-vis Articles 12.2 and 13c. In situations involving a state party's withdrawal from the statute, these provisions must be assessed systemically in light of Article 127, which specifically addresses the consequences of such a withdrawal. The appeals chamber notes that the defense argues mainly in abstract and theoretical terms, focusing on the principle of lex specialis. However, the key issue in this appeal is not how the principle is classified or applied in theory, but whether the pretrial chamber made a legal error in interpreting the statute. For this reason, the appeals chamber finds it unnecessary to address the defense's arguments on the scope and application of lex specialis, as they do not affect the outcome of this appeal. The appeals chamber considers that what is determinative to this appeal is whether the pretrial chamber incurred an error of law in its interpretation of the statute. In the view of the appeals chamber, the provisions in Part 2, read together with Article 127.2, settle the legal regime applicable to situations of a state party withdrawal. Accordingly, the appeals chamber finds no error in the pretrial chamber's interpretation of Article 12.2, as requiring that the relevant state be party to the statute at the time the court exercises its jurisdiction, read together with Article 127, which establishes when the withdrawal takes effect and the regime applicable under these circumstances. For the aforementioned reasons, the appeals chamber unanimously rejects the defense's first ground of appeal. I shall now turn to the second ground of appeal. Under the second ground of appeal, the defense argues that the pretrial chamber erred in finding that a preliminary examination may qualify as a matter under the consideration of the court within the meaning of Article 127.2. The appeals chamber rejects this argument of appeal by majority. Judge Lotkipanidze dissents on this point. His reasons are set out in detail in his dissenting opinion. Therefore, my references hereafter to the appeals chamber shall be understood in light of this qualification, meaning that the relevant findings pertain to the majority of the appeals chamber, as Judge Lotkipanidze is partially dissenting. Under its second ground of appeal, the defense raises 4 subgrounds of appeal. First, the defense contends that the pretrial chamber adopted an overly broad interpretation of the term matter under Article 127.2 and failed to give due weight to other language versions of the statute in interpreting this provision. Having examined the arguments raised by the parties and participants, the appeals chamber finds that the pretrial chamber properly assessed the ordinary meaning of the words any matter under consideration and did not expand them to include a mere concern or thought. Moreover, it did not espouse a particular reference for the English version of the statute. Rather, in accordance with the test set out in the Vienna Convention on the law of treaties, it embraced the interpretation that best reconciles any difference of wording in the texts in favor of a broad reading of the phrase any matter. Therefore, the appeals chamber does not discern any error in this respect. Second, the defense alleges that the pretrial chamber erred in law by finding that a preliminary examination renders a matter under the consideration of the court within the meaning of Article 127.2. Having analyzed all submissions received, the appeals chamber also rejects this argument. The appeals chamber observes that the preliminary examination phase has a clear basis in the court's legal texts, including in Articles 15 and 53 of the statute and Rules 46 to 48 of the Rules of Procedure and Evidence. In addition, the specific preliminary examination carried out in the Philippines situation properly qualifies as any matter which was already under the consideration of the court for the purposes of Article 127.2. The appeal chamber notes that in the specific circumstances as detailed in the impugned decision, the prosecutor, A, decided to initiate a preliminary examination prior to the Philippines' withdrawal from the statute, B, publicly announced the initiation of a preliminary examination, C, adopted a number of procedural steps, some of which involved judicial rulings, and D, submitted a request to initiate a proprio motu investigation on the basis of the results of the preliminary examination. As a result, the appeals chamber dismisses this argument. Third, the defense argues that the pretrial chamber's application of the concept of subsequent practice in relation to the Philippines' continued engagement with the court after its withdrawal was legally inappropriate and factually incorrect. The appeals chamber recalls inter alia that in the context of its request to defer the prosecutor's investigation under Article 18.2, the Philippines underlined that the court lacks jurisdiction over the Philippines situation. The appeals chamber is of the view that the Philippines' decision to arrest and surrender Mr. Duterte, as well as its further engagement with the court, is insufficient to support a conclusion that the practice of the Philippines following its withdrawal qualifies as subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation within the meaning of Article 21.3b of the Vienna Convention on the Loan Treaties. The appeals chamber cannot objectively discern how the trial could have reasonably reached said conclusion. The factual conclusion reached by the pretrial chamber amounts to an error of fact in the particular circumstances at hand. Nonetheless, this error did not materially affect the impugned decision, as it did not constitute a determinative but rather an ancillary element in its analysis of the pretrial chamber. As a result, the appeals chamber dismisses this argument. And then the fourth subground, the defense contends that a preliminary examination and a decision to open an investigation are definitely not identical, since the consideration of each of them is carried out by different organs of the court, and is subject to distinct provisions. The appeals chamber is not persuaded by this line of argumentation. There is no strict separation between the preliminary examination and the opening of a proprio motu investigation, as they constitute two components of an integral legal procedure, without prejudice of the organ conducting the relevant steps. Therefore, the appeals chamber finds no error in the conclusion reached by the pretrial chamber. Judge Lord Kipanidze considers that the pretrial chamber erred in law in its interpretation of Article 127.2, namely that the court can exercise its jurisdiction over the alleged crimes in this case. For the reasons set out in his partially dissenting opinion, he is of the view that the prosecutor's preliminary examinations are not a matter under the consideration of the court within the meaning of Article 127.2, and that a situation is only under the consideration by the court once a pretrial chamber authorizes an investigation into that situation. Accordingly, he would have granted the defense's second ground of appeal and found that the court cannot exercise jurisdiction in the present case. For the foregoing reasons, the appeals chamber, by majority, rejects the second ground of appeal. Judge Lord Kipanidze is partially dissenting. He would have granted the second ground of appeal, and accordingly, he does not find it necessary to address the third and the fourth grounds of appeal. I shall now turn to the third ground of appeal. Under the third ground of appeal, the defense alleges that the pretrial incurred an error of law in interpreting that the term "the court" in Article 127.2 include the office of the prosecutor. The pretrial chamber noted that the word "court," which is capitalized in this article, refers to the institution of the International Criminal Court as per Article 1 of the statute, rather than the judicial chambers. It further considered that, as stated in Article 34, the court is composed of 4 organs, including the office of the prosecutor. The appeals chamber observes that, in line with the interpretative methodology required by the Vienna Convention on the Law on Treaties, the pretrial chamber first considered the ordinary meaning of the word "court," noting the ambiguities in the ordinary meaning of the word. The pretrial chamber then considered the context of the term in the statute as a whole, as well as by reference to the context in which it is used in Article 127 itself. The appeals chamber finds that the statute employs the term "the court" in distinct senses, and it must be ascertained which one is appropriate with respect to the provisions under interpretation. Having considered the analysis of the pretrial chamber, particularly regarding the context in which the term "the court" is used in both the statute and in Article 127, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in finding that the term "the court" includes the office of the prosecutor for the purposes of Article 127.2, and therefore the appeals chamber rejects the third ground of appeal. I now turn to the fourth ground of appeal. Under the fourth ground of appeal, the defense argues that the pretrial chamber erred in finding that the object and purpose of the statute permits the opening of an investigation even after the effective withdrawal of the Philippines from the statute. According to the defense, in adopting its legal interpretation, the pretrial chamber made a policy-oriented determination. The appeals chamber cannot discern any error in the pretrial chamber's interpretation of Article 127. The appeals chamber is not persuaded by the defense's omission that the one-year withdrawal period under Article 127(1) sufficiently preserves the statute's object and purpose, as the prosecutor may seek an investigation within this period. As noted above, if the prosecutor is satisfied that a reasonable basis exists to open an investigation proprio motu, he or she is under the obligation to present an application for authorization to do so to the pretrial chamber. The continuation of the preliminary examination past the one-year withdrawal period is reflective of the balance found by the appeals chamber between the responsibilities that states accept upon ratification of the statute, including the aim set out in the preamble to put an end to impunity, and the ability of the states to effectively withdraw from the statute within a clear timeline. The appeals chamber further notes that the pretrial chamber's assessment of certain facts led it to conclude that there is a direct relationship between the prosecutor's announcement of the opening of preliminary examination and the decision of the Philippines to withdraw from the statute. The defense contends that the pretrial chamber unduly relied on a subjective political critique. However, in the opinion of the appeals chamber, the pretrial chamber interpreted Article 127 in line with the methodology set out in the Vienna Convention on the Law of Treaties and its discussion of the Philippines' potential motivations for withdrawing from the statute did not form part of the reasoning contributing to its legal interpretation of Article 127(2). Rather, having explained why the object and purpose of the statute also supported its interpretation of Article 127, the pretrial chamber merely referenced certain facts to provide an example of what Article 127, read as a whole, is designed to prevent. Therefore, the appeals chamber considers that the defense has failed to demonstrate that the pretrial chamber committed an error of law and rejects the fourth ground of appeal. The appeal chamber, by majority, as a conclusion, Judge Orquipanise, partially dissenting in the second ground, has rejected all four grounds of appeal. Having rejected the entire appeal, the appeals chamber considers that the defense request for the immediate and unconditional release of Mr. Duterte is moot. In the appeal pursuant to Article 82(1)(a) of the statute, the appeals chamber may confirm, reverse, or amend the decision appealed. In the present case, the appeals chamber by majority confirms the impugned decision. Judge Orquipanise appends a partially dissenting opinion. This brings us to the end of the summary of the appeals chamber's judgment of today. Finally, I would like to end by thanking all the parties, participants, and their counsel, registry staff, and interpreters who have assisted with today's hearing. There is a lot of work that goes on behind the scenes to ensure that these hearings runs smoothly, and the appeals chamber is very grateful to all of those involved, including to IMSS for its efforts to make sure the courtroom system are available for the present hearing. Finally, I would like to thank my colleagues, the judges, and the appeals chamber's staff for their support. The hearing is adjourned.
All rise, we will obey.
Ayan mga kabombo at mga ka-Star Nation, napakinggan at napanood po ninyo ang mga kaganapan sa International Criminal Court. Babalikan lamang natin ang ilang mahalagang yugto doon sa naturang desisyon ng Appeals Chamber. Dito mga kabombo at mga ka-Star Nation ay pinagtibay nga ng International Criminal Court ang jurisdiction para sa kaso laban kay dating Pangulong Rodrigo Roa Duterte kaugnay ng mga nangyaring pagpaslang sa ilalim ng kampanya kontra sa illegal na droga sa Pilipinas. Sa naging desisyon nga mga kabombo ay ibinasura ay yung mga argumento ng kampo nitong si former President Duterte na wala raw kapangyarihan ang International Criminal Court matapos na umatras ng Pilipinas sa Rome Statute noong 2019 at naging epektibo na rin sa naturang panahon. Ayon sa korte, hindi maaaring gamitin ng isang estado ang pag-atras upang mailigtas ang sinumang individual sa pananagutan sa mga krimen na iniuugnay o inaakusa laban sa kanya dahil nangyari ang ilan sa mga inaakusa bago pa man ang withdrawal sa Rome Statute. Mga kabombo at mga ka-Star Nation, ang tinutukoy dito yung mga kaso ng mga pagpaslang na naitala sa panahon ng Duterte administration. Binabanggit din mga kabombo kanina sa naging pagbasa ng desisyon yung preliminary examination umano na sinimulan noon pang 2018 ay bahagi ng proseso. Kaya't saklaw pa rin ng korte ang mga kaso kaugnay ng drug war. Si dating Pangulong Duterte ay naharap nga sa 3 bilang ng mga kaso ng pagpaslang at meron pa mga karagdagan kaugnay dun sa 49 na mga pagpaslang din sa iba't ibang dako ng ating bansa. At ito ay habang tinatalakay, hinihimay pa yung ilang mga usapin tungkol dito sa naturang kaso. Ibig sabihin mga kabombo, mga ka-Star Nation, uusad yung kanilang mga proseso pa dyan sa International Criminal Court. Bagamat wala pa hong pinal na pasya ukol naman doon sa naging confirmation of charges sapagkat ang desisyon ukol ho dyan ay ilalabas naman pagsapit ng 30 ng Abril ng taong kasalukuyan. Itinuturing ito mga kabombo na malaking tagumpay para sa panig ng mga biktima at prosekusyon, lalo na ang tinatayang umaabot ho sa 12,000 na mga individual na sinasabing napaslang sa naturang panahon, bagamat ito ay tinatanggi o pinabubulaanan ng kampo ng dating Pangulo. Sa kabila naman mga pagtatangka na ipatigil yung investigasyon ay naglabas nga ng ganitong desisyon ang International Criminal Court at maaari na umusad pa ang ibang mga kaganapan dyan sa international body pagsapit naman ng mga susunod na araw. Bagamat ito mga kabombo ay bahagi ng mga proseso at kailangan ding tumalima doon sa mga patakaran. Medyo mahaba yung mga proseso ho dyan kaugnay ng naturang usapin sapagkat ito'y masalimuot mga kabombo at mga ka-Star Nation. Yung ating nga palang naudlot na panayam kanina dito kay Attorney Cortez, ilang punto pa ang nais ko pong maitanong at tangkop pa rin para dito sa ating mga tagapanood at tagapakinig. Ito hong usapin ng pasya mula sa panig ng International Criminal Court. Paano yung kumbaga para sa panig nitong si former President Duterte? Ito ho kaya ay pwedeng i-apila, ano? Okay. magkakaroon po ng mga karagdagan pang update mamaya. I-check natin muna yung iba pang mga kaganapan and we'll check also doon sa Kamara de Representantes, kaugnay naman doon sa mga development sa impeachment hearing dito kay former Department of Education Secretary at Vice President Sara Duterte naman dyan sa bahagi po ng Kamara, mga kabombo at mga ka-Star Nation. I-check natin yan maya-maya and of course sa panig ng Senado ay kuha din tayo ng ilang mga reactions hinggil sa mga usapin na napapanahon sa mga pagkakataong ito. At kukuha lamang tayo mga kabombo ng iba pang mga panaya. Maya-maya lamang, oras natin sa buong kapuluan ay meron na lamang ho tayong nalalabing 20 minuto bago ho sumapit ang alas 6 ng gabi, bago ho ang pag-usad pa ng ating mga balitaan ay kinukontak ho natin sa mga pagkakataong ito yung ilan sa mga resource person natin and pati na yung ating mga beat reporters sa bahagi po ng lungsod ng Quezon at this point in time mga kabombo, mga ka-Star Nation. And yung iba pa hong mga abogado na makakapagpaliwanag ho sa atin ukol sa kahihinatnan ho nitong issue ng reklamo na kinakaharap ni former President Rodrigo Roa Duterte dyan sa International Criminal Court. And we're trying to contact yung iba hong mga resource person natin from the side naman ni former President Rodrigo Roa Duterte ay kinukuha natin yung kanilang panig para naman sa kanilang masasabi hinggil ho dito. Any reaction from their side para ho makuha din natin yung kanilang sentimiento at saloobin and kung ano yung kanilang mga plano hinggil po dito mga kabombo at mga ka-Star Nation na atin hong patuloy na tinutugay-gayan sa mga panahong ito. And at this point, check natin dyan sa camera yung ating coverage team. We have Bombo Isa Cotoner and Bombo Grant Hilario to check on any development dyan ho sa hearing kaugnay naman doon sa kaganapan dyan sa House of Representatives, mga kabombo at mga ka-Star Nation. And pati ho yung mga lumabas kanina na mga nagbigay ng kanilang testimonya, yung mga resource person, pinanumpaan ho nila yung kanilang salaysay and we'll check about dun ho sa kabuuan. O kumbaga kung lalagumin yung kabuuan ho ng pagharap ng ilang mga personalities. We have former Senator Antonio Trillanes IV, we have Ombudsman Boying Rimulya and representatives from Bureau of Internal Revenue, Securities and Exchange Commission, and of course, yung Anti-Money Laundering Council na mahaba ho yung kanyang exposure doon sapagkat marami yung binerify na dokumento para ho dito sa naturang pagdinig. Ilan lamang ho dyan yung mga accounts kung nagkaroon ng transaksyon na kahalintulad ho nung hawak nitong si former Senator Trillanes. At pinapakita naman natin na natili hong bakante yung upuan na nakalaan para kay Vice President Sara Duterte habang isinasagawa yung naturang pagdinig. Kung nagkataon pala mga kabombo, mga ka-Star Nation, magkatabi itong si former Justice Secretary, former Senator at ngayon ay mamamayang Liberal Party List Representative Leila de Lima at si Vice President Sara Duterte. Ito ho ang base doon sa seating arrangement na ipinapakita po natin na kani-kanina lamang mga kabombo sapagkat ito yung pagkakaayos doon sa kanila para sa nakalaang upuan dito kay Vice President Sara Duterte. Kaya lang hindi ho siya nag-appear o hindi siya nagpadala ng kanyang kinatawan para sa panibagong pagbibigay ng panig, kaya ho na natiling blanco yung kanyang silya o yung upuan na nakalaan po para kay Vice President Sara Duterte dyan sa Kamara de Representantes, mga kabombo, sa kabuuan itong hearing po na ito. And every time na magkakaroon ho ng pagkakataon ay ina-acknowledge kung nandyan na ang Vice President, pero sa kabuuan po ng mga pagtawag ng chairperson si Batangas Representative Jervil Luistro ay wala hong tumutugon. Ibig sabihin ay negative. Hindi humarap ito si Vice President Sara Duterte. But of course, ito ho naman mga kabombo ay procedural lamang. Hindi naman talaga nila inaasahan na halos na haharap ito si Vice President Sara Duterte sapagkat doon ho sa mga nakalipas na press conference at mga pronouncement ay sinasabi na wala nang rason para humarap dahil na-prejudge na raw siya. At kaugnay ho niyang issue tungkol po dyan sa kinakaharap niyang usapin. Sabi nga niyan, yung termino pa lang na ginamit na mini trial ay hindi raw ho sang-ayon itong si Vice President Sara Duterte kaya ho dumulog sa Korte Suprema dahil hindi trabaho ng mababang kapulungan ng Kongreso na mag-conduct ng trial, mini trial man ito, anumang klase ng trial, hindi raw ho ito dapat gawin sapagkat ang proseso ay kinakailangan gawin dun ho sa bahagi ng Senado bilang impeachment court kung sakasakali naaabot ang naturang reklamo sa naturang kapulungan mga kabombo at mga ka-Star Nation. Check na natin yung linya mga kabombo ng ating coverage team kaugnay ng impeachment related issues dyan po sa Kamara de Representantes. Check muna natin si Bombo Isa Cotoner o kaya si Bombo Grant Hilario sapagkat nakatuon po ang kanilang atensyon mula ho kanina dun sa pagharap dyan sa isinagawa hong appearance o sasalaysay nitong si Ombudsman Jesus Crispin Boying Rimulya ay tinutukan po natin yan sa pamamagitan ng ating coverage team. And at this point, i-check natin yung Senate muna sapagkat yung iba pang may kaugnayan ho dito sa usapin na ito mga kabombo at mga ka-Star Nation. Check natin dyan sa Senado si Bombo Angelo Aganan. Check natin dyan sa Senado. By the way, si Bombo Genesis muna sapagkat may ilang recap lang ho tayo kaugnay doon sa mga naging takbo ng mga tinutukan po nating development. Dahil importante mga kabombo, mabalikan natin para ho doon sa mga late tuners ho natin, nakakabukas lamang ho ng kanilang Bombo mobile app. Yung iba nga kakapanood lamang ho sa Facebook Live dahil galing ho sila sa biyahe. So i-check ho natin, konting recap para sa ating mga late tuners. By the way, ito ho mga kabombo, sunod-sunod yung mga kaganapan ngayong araw po na ito and we're trying to connect the dots sapagkat may local, may international scene natin hong binabantayan and of course we are still checking doon ho sa mga kaganapan din sa Middle East sa kapakanan po ng ating mga kababayan doon, mga kabombo natin at mga ka-Star Nation na affected po nitong sitwasyon dyan, lalo na yung mga overseas Filipino workers na nakakaugnayan din ho natin mga kabombo sa mga nakalipas na pagkakataon. Check natin si Bombo Genesis and ito'y related pa rin doon sa ating mga mga tinutugay-gayan ng mga development. Bombo Gen, please come in.
Yes, Bombo Dennis, mga kabombo Star Nation, ikinatuwangan ng mga pamilya ng mga drug war victim itong naging desisyon ng International Criminal Court kung saan ay ibinasura ng International Criminal Court Appeals Chamber yun ngang unang ground ng apela ni dating Pangulong Rodrigo Duterte kaugnay dito sa jurisdiction challenge. Kung babalikan ay nagkaroon na dati ng desisyon dito ang International Criminal Court Pre-Trial Chamber 1 pero umapela kasi ang kampo ng dating Pangulo at iniakyat ito sa Appeals Chamber. Bombo Dennis, mga kabombo, ngayon ay nagdesisyon din ang Appeals Chamber at ibinasura muli yung apela ng kampo ni dating Pangulong Rodrigo Roa Duterte. Mapapansin dito sa isinasagawang Justice Watch ng mga pamilya ng mga nasawi o namatay na mga kababayan natin dahil dito sa madugong drug war na isinagawa noon ni dating Pangulong Rodrigo Duterte ang kanilang kasiyahan matapos nga nitong desisyon ng International Criminal Court. Mapapansin ng ating mga kababayan, mga viewers natin o mga nanonood sa atin etong tuwa ng mga pamilya ng mga biktima Bombo Dennis, mga kabombo Caster Nation, ang sigaw nila dito, ituloy lamang ang laban at yung hearing or yung trial para kay dating Pangulong Rodrigo Roa Duterte na nahaharap nga sa kasong crimes against humanity. Sa mga naunang panayam na Bombo Radio Philippines sa mga pamilya ng mga drug war victims Bombo Dennis, mga kabombo Caster Nation, patuloy silang umaasa na sa lalong madaling panahon ay matuloy na yung trial laban kay dating Pangulong Rodrigo Roa Duterte. In fact, sa naunang panayam ng Bombo Radio Philippines kay Attorney Efraim Cortez, ang presidente ng National Union of People's Lawyer, na kasama rin dito sa Justice Watch ngayon Bombo Dennis, ay sabi niya yung usap-usapan kapag or inuphold ng International Criminal Court Appeals Chamber etong jurisdiction issue or inuphold nila yung jurisdiction nito dito sa Pilipinas, ay posibleng by June ay magkakaroon na nga ng trial. June hanggang September. Yan yung usap-usapan sa legal community Bombo Dennis. So after nga nitong desisyon ng International Criminal Court, ay patuloy yung positibong pananaw ng mga drug war victim na kahit papano within this year ay masisimulan na ngayong trial laban kay dating Pangulong Rodrigo Duterte na naharap sa kasong crimes against humanity. Magbabato pa rin tayo ng update mamaya Bombo Dennis sa kaganapan dito sa Justice Watch na ginagawa o isinasagawa ng mga pamilya ng mga drug war victim Bombo Dennis.
Okay, sige. With that, maraming salamat Bombo Genesis, and i-check pa natin maya-maya yung mga update mula dyan sa iyong panig. From your end, Bombo Gen?
Back to you Bombo Dennis.
Mga kabombo at mga Castar Nation, yan po yung mga update natin kaugnay dun sa viewing na ginagawa ng mga miyembro ng pamilya nitong mga war on drugs victims. And nandyan din ho yung kanilang mga abogado. In fact, kanina na-interview natin live si Attorney Nery Colmenares. So, check natin maya-maya mga kabombo, yun namang panig ng kampo ng mga Duterte after nito mga development na ito. Antabay ho, dahil alas 6 ng gabi, Bombo Network News ho tayo. Ihakatid natin mga latest information kaugnay naman ng iba't ibang malalaki pang kaganapang ating tinugay-gayan sa maghapong ito. Stay tuned mga kabombo, at yung ating mga stations ay unload muna ho tayo ng ating mga commercials and will proceed alas 6 ng gabi sa Bombo Network News. Rito sa Bombo News Center, Makati, this is Bombo Radio Philippines, the #1 and most trusted source of news and information. Basta Radio, Bombo!
For the most trusted source of news and information, visit our website at www.bomboradio.com. Follow us on Bombo Radio mobile app, Facebook, YouTube, TikTok, and X, formerly Twitter. Like, share, and stay connected. Anytime, anywhere.
Sama sa pagpatay sa suga kung magawa sa kwarto, pag-unplug sa charger kung dili na gamiton, o paggamit sa natural nga hayag sa adlaw.
Kini nga mga practice magaluwa sa gasto sa pamilya ug magtudlo sa kabataan sa responsibilidad ug pag-atiman sa kalibutan.
Ang maayong batasan sa enerhiya nga masugdan sa bata o sa kapuhunan na alang sa ligon ug malungtaron nga kinabuhi.
Mga tips aron makanaginot sa gas ang imong sakyanan. Una, likayi ang kalit nga pagpakusog o kalit nga pag-brake. Mas maayo ang hinay-hinay o makanunayon nga pagtunog sa gas.
Ikaduha, sakto nga dagan. Sa highway, ang dagan nga 50 km per hour to 90 km per hour ang pinaka-fuel efficient. Ang sobra sa 100 km per hour mas dako og konsumo sa gas tungod sa wind resistance.
Ikatulo, ang imong sakyanan kung anaay i-commode, gamita kini aron malimitahan ang engine performance ug makanaginot sa gas.
Ikaupat, ayaw pasagdi nga mag-andar ang makina kung naghuno nga dugay kay usik kini sa gas.
Ikalima, siguruha nga hugot ang tabon sa gasolinahan aron dili mo ma-break ang gas.
Ikaunom, ayaw pagdala og mga butang sulod sa sakyanan o sa roof rack kung dili kini kinahanglan. Kay kung mas bugat ang sakyanan, mas kusog kini mukaon og gas.
Ikapito, gamita ang aircon sa saktong pagi. Kung dili nginit ang panahon, mahimong hinayan lang kini sa paggamit. Usa ka minungdanong pahinumdom gikan sa Bombo Radio Butuan. Basta Radio, Bombo!
Mga tips aron makalaginot sa kuryente samtang gamit ang refrigerator. Una, likayi ang sagunson nga pagbalik-balik og abres sa ref.
Ikaduha, regular nga pag-defrost o pagpalanay sa ice sa freezer.
Ikatulo, i-check kung dunay buslot o leaking ang rubber gutter sa pultahan sa ref.
Ikaupat, likayi ang pagbutang og init sa sulod.
Ikalima, ayaw i-overfill o puna ang sulod sa ref aron dunay jutay nga hangin nga makatuyok-tuyok.
Ikaunom, limpyuhi kanunay ang abog sa cooling fins o coil sa ref.
Mga benepisyo nga makuha sa pagzumba. Una, makatabang kini sa pag-us-us sa atong timbang. Ikaduha, makapaanindot sa hulma sa lawas. Ikatulo, makapawala kini sa stress. Ikaupat, makapalambo sa koordinasyon sa atong lawas. Ug ikalima, maayong paagi aron makahugoy-hugoy ang imong isig katawo. Mga benepisyo nga makuha sa brisk walking. Una, pagsunog sa kalorya. Ikaduha, pagpaligoon sa kasing-kasing. Ikatulo, makatabang sa pagpaubos sa blood sugar. Ikaapat, makapahupay sa sakit sa lutahan. Ikalima, magpaligoon sa immune system og enerhiya. Ug ikaunom, makatabang kini nga malugwayan ang imong kinabuhi.
Mga tips aron makalaginot sa kuryente gamit ang aircon. Una, iset tali sa 24 degrees Celsius ngadto sa 26 degrees Celsius ang temperatura sa aircon. Ang matag degree nga ubos sa 25 degrees Celsius makapataas sa konsumo sa kuryente ngadto sa 10%. Ikaduha, gamita og iset ang timer. Aron kini mopalong og iya pag-abot sa kadlawon o kung dili na gamiton. Ikatulo, hinloi ang filter sa aircon kada semana o kada bulan aron dili maglisod ang motor pag suyop sa hangin. Ikaapat, siguruha nga nakasilyo ang tanang bintana o pultahan aron dili makagawas ang kabugnaw. Ikalima, siguruha nga tukma ang horsepower sa aircon sa gidakon sa kwarto. Ang gamay nga aircon sa dako nga kwarto kanunay full blast nga makapadako sa kuryente. Usa ka katalingbanong pahimangno gikan sa Bombo Radyo Butuan. Basta Radio Bombo.
Ang Delta Discovery Park usa ka nindot nga suryanan sa mga mahilig og adventure. Sulayi ang kalingawan sa ziplining sa tunga-tunga ug matahom nga mga talan-awon, mag-explore sa mga hiking trails ug mag-enjoy sa kalinaw sa palibot nga naghatag og mga talagsaong panoramic views. Ug usa ka higayon aron makaig-uban balik sa kinaiyahan.